Hi, everybody, and welcome to another episode of Logically Speaking, our live on Facebook talk show for anything and everything legal, from Florida legal tips in divorce and criminal law to sometimes there might be some running your law firm business tips. But today we're going to talk about Florida divorce law. And I did a talk show, a live show with someone previously, and I mentioned on that show that adultery does not actually matter in a Florida divorce. It's not something that can typically even be brought up. And there were several comments posted on that seemed to be intriguing information or even shocking information to people. And so I thought that I would do tonight's episode on that and talk about in Florida divorce law, adultery or cheating. Does it matter? And does it even come into play in a Florida divorce? And so the answer to that is in general, no, it doesn't. Florida is a no fault divorce state. And what that means is simply that the only thing that has to be alleged in a Florida divorce is that the marriage is irretrievably broken. And that just means that nothing that the court can do, the court could, or if the court were to order you to marriage counseling or anything like that, that would not help save your marriage, that it's just irretrievably broken. The parties' marriage cannot be fixed. And that's the only thing that's alleged in a Florida divorce. Actually, Florida doesn't even allow you to allege things like adultery or cheating inside of a divorce petition. And in general, it's not even allowed to come into evidence in a Florida divorce. If the case were to go to trial in front of a judge, it is typically not something that's even admissible into evidence, as far as the reasons why the marriage is being broken up. Now, there is one small little exception to that where it can be brought up, but it's not brought up in the sense of that anybody did, that somebody cheated and that's the reason why the marriage broke up. It can be brought up only for the purposes of determination of potentially alimony or maybe something within equitable distribution to give one party a higher form of equitable distribution than the other. And that is only to be brought up into the aspect that the spouse that was cheating used marital funds or marital assets and dissipated those funds or those assets in order to fund the extramarital affair. And if a partner or a spouse did that, then the affair can come into evidence to be used against them, but only in the sense of how much money was used and how much of the assets or money was used and dissipated on the affair to potentially award the other spouse some form in some award in alimony or an unequal distribution and equitable distribution to allot for that. So that is the limited form that it would be able to be brought up. And really it's not even a factor of that it's that the spouse cheated or had an affair or committed adultery, but it's really about the dissipation of assets and then how the marital assets and equitable distribution and alimony should be determined based on the dissipation of those assets. So I hope that you found this interesting and that this was helpful and valuable information for you. Again, this is as to Florida divorce law, and I am attorney Siobhan Olivero, a licensed Florida attorney and certified divorce coach. And if you need any information or to reach us, we can be found here. You can contact me here on Facebook to have a consultation, or you can email us at info@oliverolaw.com or give us a call at 813-654-5777, and we'll be happy to discuss your case with you. Until next time, everybody have a great evening.